Well, last Sunday, as you may have heard, I based my opening editorial, one at the start of the show, on my concern that the fundamental bedrock of our legal system, that being innocent until proven guilty, has been compromised, certainly with recent cases of alleged sexual assault in our parliament, but even beyond that. As I said last week, it does appear that despite vigorous denials, the presumption of innocence is an antiquated concept from the sepia-stained pages of history. One is now assumed guilty, or so it seems, paraded on front-page spreads, the word allegedly liberally thrown about to protect against defamation, but tried in a court of public opinion. I went on to say, and in an attempt to empower women and rightly to correct the historical imbalance, we have assumed a very modern mindset that says we must believe the accuser. And by default or extension, we naturally look sceptically, therefore, at the alleged perpetrator, even if he or she vehemently denies the matter. As I said, it's as if we've developed a presumption of guilt. It was interesting reading the thoughts of the very well-regarded Terry Goldsworthy this week in The Australian. Terry, as I said before, is an associate professor of criminal justice at Bond University. He was a former Queensland detective inspector for 28 years. He knows what he's talking about. His words carry gravitas. In his article this week in The Australian, he echoed similar comments to mine. He said, two of the fundamental principles of our criminal justice system are the accused presumed innocent until proven guilty, and that their guilt must be proved beyond a reasonable doubt. As he said, these are immutable foundations of our systems of justice. And yet, if we're being fair dinkum here, you look around at some high-profile cases, look around generally at a lot of these matters that they seem to seep their way into the media. Are those fundamental foundations, those immutable foundations of our system of justice still sacrosanct? Or are they more honoured in the breach than the observance? I thought we'd speak with Terry Goldsworthy. He's on the line. Terry, very good morning to you.
Yeah, good morning, Michael.
I mean, it is a problem. I'm no legal scholar, so I defer to you here. But, I mean, from my point of view, you look at a lot of these, and we don't have to go into the detail of the cases, of course, but you look at a lot of these high-profile cases, and not just the Canberra ones of late, and you sort of shake your head even as a non-legal person and think, there's got to be a better way.
Yeah, look, I mean, it's concerning, and that's why I wrote the piece in the Australian. I just think that we're moving to a position where we're ignoring the principles of justice that underpin our criminal justice system, and they're there for a reason. I mean, there's a large imbalance of the state versus the individual, and that's why we have the onus of proof on the prosecution, and to the burden of proof is beyond a reasonable doubt, and that's why you're presumed innocent until you're proven guilty. And it seems that in certain categories of crime, and it is only certain categories of crime, certain parts of society are now prepared to flip that on its head and say, well, we think you're guilty, let's see you prove your innocence. And that's not how it should work.
No, let me ask you this. Has this all got worse? That is to ask Terry. Of course, since newspapers were first printed off presses and the like, we've always had an element of intrigue and gossip, in scandal, in salaciousness, and all the rest of it. So, cases of sexual assault, allegations, and whatever, they've always been considered and deemed newsworthy. Criminal matters, of course, always have been the bedrock of media and publications. But has there been a loosening of the way in which these matters are now reported, the language in which all of this is disseminated? As I said, it all seems to be sort of whitewashed with the constant usage of the word allegedly, as if that sort of exonerates anything. But are we getting sloppy in this?
Oh, I think we are. I think we've seen a real abuse of the principle of sub judice, which means that when a matter is under trial or being considered by a court, we should have limited commentary in public about the actual matter. And I think there's some recent cases where that was thrown under the bus without any doubt of fact. So that is a concern in terms of how we're representing these matters. The Me Too movement, I think, was a real catalyst for highlighting issues, which was quite good, but I think it's been hijacked and has lost some of its vigour. And I do see a number of feminists now commenting that they think Me Too is problematic in terms of feminism, etc. because it's gone too far in some respects as to moving some of the principles that we have in place. And these issues are contentious. And I think it points to a wider issue that, as an academic, etc., we're meant to engage with contentious issues. And the very meaning of contentious is that there's an argument or debate. In some of these matters that we've seen come forward in the criminal justice system, there has been no room for any kind of suggestion or debate about the merits of the case or otherwise. It's simply been a finding of guilt in the media, and if you dare suggest otherwise, then you're hung out as a pariah. And there's almost like an absolutist groupthink that you need to surrender your intellect, and if you don't agree with the proposition being put forward, then you'll be dealt with. And I think that's quite dangerous in a democratic society.
Best to shut up if you don't want to join the pylon, I guess. You mentioned the word pendulum there. In my editorial last week, I wrote the pendulum in the past was, and I think you'd agree, certainly too far gone to one side, certainly too far in favour of the man. Perhaps, though, it's now swung or is swinging too far in the opposite direction. And I said that, and I acknowledge as knowing many would disagree, and that's fine. That's what happens in a democracy. But I think everybody, surely, Terry, would agree that we must ensure that in the good, righteous, noble fight to rid our workplaces and society of sexual assault and harassment, we don't lose the fundamental bedrock of the legal system, which, as you've written, is the presumption of innocence as well as procedural fairness. And yet, so you look around and you think, well, that's gone in many respects. It seems to have.
Well, that's right. I mean, if you look at the Start By Believing campaign, and, I spent 10 years working with a non-government organisation that supported victims of sexual assault, and so I'm very familiar with this campaign. It's almost morphed into you must continue to believe in the face of any adverse evidence. Now, that's problematic. I mean, police, 28 years of policing that I had, you take your complainant on face value. So you do believe what the complainant is telling you until you have reason to consider that there may be issues with the complainant's version. So when police investigate matters, they look for evidence to support the complainant's version. Often that may well also uncover evidence that is problematic for the version. We've seen some suggestions in recent times in some public inquiries that the thought process amongst some is that almost that the police should not be doing any investigation for fear they may uncover something that compromises the version given to them, and that their role is not to actually do much investigation at all. And I just think that is so problematic. It's quite concerning. In
other words, they may come across evidence which leads them not to believe any further.
Well, that's right. You may come, say someone says, I was at a bus stop at 10:10 when this happened, and you look at the bus stop footage, there's footage, and they're not there at 10:10. You need to go back to the complaint and say, we've looked at the footage, you're not there. They may go, oh, sorry, my watch was half an hour late. So you may be able to account for the inconsistency, but to ignore it for fear that it may show a problem with the prosecution case, I think is almost paramount to assisting in a miscarriage of justice.
Yeah, and of course, then we end up, don't we, and you've written about this, we end up with a number of cases go before courts, and there are a number of judges writing, I think in the Australian last week or the week before, observing that matters were now proceeding to court where there was no reasonable prospect of a conviction, and yet nonetheless it seems people feel compelled to get it there before the magistrate nonetheless. I mean, that doesn't benefit anybody, does it?
No, it doesn't. And what that is a form of risk management by the prosecutors and the police to some degree that in the current environment for certain offences, categories where they're quite risk adverse to not proceeding with the matter for fear of criticism from various groups and societies. So they will proceed with any matter on the expectation that we'll let the jury sort it out and hopefully they'll come back with the right decision. And this is it's interesting that this concept was or this issue was identified by judges only last week because there's a video done by SBS in 1999 and it followed a husband and wife defence barrister team Victoria, one who's now a county court judge down there. And the female, the wife, was defending a historical sex accusation. And she even back then made the accusation or made the observation. They said, why is this matter going to court? And she goes, well, it shouldn't go to court. But what we're seeing is that the prosecutors are so risk adverse that they're now putting everything before the court. So this is a trend that's developed over time, but has certainly gained momentum in the last 4 or 5 years.
You see, the problem, and again, I say all of this as a non-legally qualified person. I'm just an observer. I've got a microphone. That's it. But the problem here is, let's assume a case goes to trial. Even before that, we get everything in the front page and the media, and they all have their 2 bobs worth on it. Yeah, let's say ultimately somebody is found innocent or the trial's thrown out. There's not enough evidence or whatever. The person who's been accused may well legally have their reputation restored, their name cleared, but in the court of public opinion, a lot of people don't follow through, do they? So, I mean, they might read the headline 6 months ago, or Joe Bloggs did this, or, Jane Doe did that. 6 months on, it's all thrown out, or no, that didn't happen. But people don't follow through. And so in a lot of people's minds, Joe Blogg or Jane Doe are bad people. Their reputation is trashed. Often they don't get work ever again. They're untouchables, despite being innocent. I mean, this is where the rubber hits the road in the real world, isn't it?
Well, the saying, throw enough mud, some will stick, applies. And there's also the issue of cost. It's very difficult to get legal aid. So many people face substantial costs to defend matters that should never have probably been taken to court. And of course, the other issue you have there is for the complainant. So where there's a problematic case where there's very little prospect of success, conflicting versions, etc., this kind of thought process that everything will go to the courts because we don't want to be criticised would probably unfairly raise the hopes of complainants where the matters are doomed to fail.
Yes.
You then have to consider, well, what damage does that do the complainant when they expect some kind of outcome, and it's just never going to occur.
Now, just before you go, this term weaponisation has certainly got a bit of a run the last few months for obvious reasons, but it's not a new concept. Nonetheless, it is empowered, is it not, when we sort of assume this mindset of, legally speaking, you must believe the accuser. There is the likelihood that some people will then see, well, okay, if the default position is I say something, therefore I'm believed, the person I accuse is seen as a villain unless they can inadvertently prove their innocence. There is incentive perhaps for malicious types to use these accusations. The weaponisation gets a bit of a kick along.
Oh, it does. And, as you said, we have seen some matters, one particular matter in recent times where, through the efforts of some very, I think, brave and diligent journalists, exactly what has gone on. You do see this weaponisation. And, in the Me Too, peak, where we saw anyone getting accused of any kind of misdemeanours, their career came to a halt. Their employment was ceased. And yet nothing had actually been proven to any standard of law. So, I mean, it can be a very effective way to attack someone. The problem is that where you have instances where you can show that it was a weaponised attack, it does immeasurable harm to the many, many victims who don't weaponise their complaints and just want to go through the criminal justice system framework as it should do. And that's the real sadness here, that victims who just want to proceed through the way it should suffer because of the public debate around the weaponisation of some of these issues. It's just really unfortunate for those people who aren't involved in that.
That's right. That's brilliantly said. I'll leave the last word, and you quoted the eminent English jurist William Blackstone in your piece, who wrote that famous adage, better that 10 guilty persons escape than one innocent suffer. That really was part of the logic, wasn't it, of the legal justice system? It seems these days there are those that are trying to flip that on its head. As you say, too often than not, the actual victims of all of this are those that are legitimate victims trying to pursue legitimate claims, who get, whose cases and whose situations start to get besmirched and muddied by everything else that we've just spoken about.
Well, that's right. And the problem you have, if you take the flip side and you go, oh, let's just throw everything to the courts, and if we happen to get a few innocent people convicted, that's unfortunate. We have great faith that eventually our court system will identify that and will be identified as miscarriage of justice. The more miscarriages of justice that you have where innocent people are convicted does nothing but increase scepticism about the efficiency of our criminal justice system, and that's problematic. We don't want people to become sceptical of our criminal justice system.
Indeed. Brilliantly said. Look, so grateful for your time and your wisdom and your scholarship on this. Thank you so much, Terry. Much appreciated.
Thanks, Michael.
My pleasure. Terry Goldsworthy there, Should be listening to that sort of stuff. That's important. He's the Associate Professor of Criminal Justice at Bond University, former Queensland Detective Inspector for 28 years. As I said, his words carry some gravitas. None of that, of course, and I just say this just to make the point, none of that is in any way to diminish or question the legitimate claims, and there are sadly thousands of them, of sexual harassment and assault. As I said last weekend in my editorial, where it occurs, doesn't matter what the workplace, doesn't matter the environment, it's got to be stopped. There's no place for it. No place for it. But equally, in our legal system, there should be no place for weaponisation, and there should be no place where the burden of proof is flipped so that people are guilty until they can prove their innocence. It does seem, at least anecdotally, that is a trend that is emerging. It's got to be turned back.